हाँ भाई तो लास्ट क्लास में अपन ने कुछ केसेस देखे कि जो कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट है वेदर इट इज अ लॉ और नॉट इफ इट इज अ लॉ देन इट कैन नॉट वायलेट द फंडामेंटल राइट इफ इट इज नॉट अ लॉ देन it can violate the fundamental right. So Supreme Court has given various judgment in this matter, and in the first case I have discussed earlier that numerous cases has been discussed. Yeah. Okay. Now, as we have stated that first the case has been started from the Bihar government because Bihar government has, I have discussed earlier, but I am doing the quick revision on it. So basically, Bihar government introduces a Land Reform Act, LR Act. In response to that, British Bihar High Court struck down this law, this act. Then, in response to that, Parliament enacted First Constitutional Amendment Act. By First Constitutional Amendment Act, Parliament added Article 13(1)(a), 13(1)(b), and Schedule 9. So added Article 13(1)(a), 13(1)(b), and Schedule 9. According to 13(1)(a), Schedule 9. Sorry. According to 13(1)(a), any law made for purpose of achieving certain object mentioned in 1 minute. Okay. So Article 13(1)(a) says that law made to give effect to certain objective can't can even violate fundamental right under Article 14, 19, 31. Now in 13(1)(b), Parliament says that law placed under Schedule 9 cannot be challenged in Supreme Court, and Schedule 9 includes those laws. Now, this Parliament has enacted the first Constitutional Amendment Act and added 13(1)(a), 13(1)(b), and Schedule 9. 13(1)(a) states that law made to give effect to certain objective to achieve certain objective can even violate the fundamental right under Article 14, 19, and 31. And also Parliament added in this amendment 13(1)(b) where Parliament said that law placed under Schedule 9 can even violate the fundamental right under Article 14, 19, and 31, and also added Schedule 9. And in Schedule 9 they include some provisions. Now in this case this has been challenged because it even violates the fundamental right, so it has been challenged in Shankari Prasad case. I have already discussed on it. So it has been challenged in Shankari Prasad case. Shankari Prasad versus Union of India. So first Constitutional Amendment Act has been challenged in the Supreme Court by the Sankri Prasad. Now, Supreme Court has to examine in this case that if CAA is a law, then it can violate the fundamental. If it cannot violate the fundamental right, if it is not a law, then it can violate the fundamental right. So Supreme Court says in this case, Parliament have two types of power. First is to make the statutory law. Second is to amend the constitution. But in those power, the law which has been made by the ordinary law is subject. It cannot violate the fundamental right. Basically, law made by ordinary law cannot violate the fundamental right, that is, it will be considered as law. But if Parliament passes the Constitutional Amendment Act, then it is not a law, that is, it can violate the fundamental right. So in the Sankari Prasad case, Supreme Court stated this. Now basically they are saying that Article 368 is giving more importance than fundamental right. That's the basically. Now this case has been again challenged in this Sajjan Singh Sajjan Singh versus State of Rajasthan. We have already discussed this time discussing about it. 1965. In this case, again Supreme Court has to examine that if the CA is a law or not. So again, Supreme Court says in this case, Supreme Court says if CA is a law or not, that the Supreme Court has to determine. So Supreme Court says and reiterate its previous judgment, that is in Sankari Prasad. But this opinion has been given by 3:2. So the opinion of two judges, which has been against to it, that they are saying that CAA is not a law, then what is here him argument? So the two judges, Justice Hidayatullah and Justice Mudholkar, Justice Hidayatullah says that fundamental rights are unamendable. Therefore, if you are amending the fundamental right, then basically you are saying Parliament is equivalent to Constituent Assembly who had drafted the Constitution of India. Now, because Constituent Assembly is not equals to Parliament. Now, let's discuss what the Justice Mudholkar says. Justice Mudholkar says that there should be there should be there should be limitation there should be limitation on power of Parliament to amend the Constitution. So in this Justin versus State of Rajasthan, again the Supreme Court reiterated the judgment, but the opinion of two judges who have given against to the judgment, it shaped the opinion of upcoming judgment in the IC Golaknath versus State of Punjab. So in this case, Jan Singh versus State of Rajasthan, the judge who have against to it was Justice Mudholkar and Justice Hidayatullah. Justice Hidayatullah says fundamental rights are unamendable because Constituent Assembly is not equivalent. Parliament is not equivalent to Constituent Assembly. Basically, if you are amending the fundamental right, then you are placing Parliament equivalent to Constituent Assembly, which is not the theme of the Constitution maker. And Justice Mudholkar says that there should be a implied limitation on amending the Constitution of India on Parliament. Now, again, if because the judgment has been given in the favor of uh, government. So this has been again challenged in the court in the case of IC Golaknath versus State of Punjab. And in this case, 17th Constitutional Amendment Act has been challenged in the court. 17th Constitutional Amendment Act had been challenged in the court, and in this case, 11 judge bench has been formed. And in this case, Supreme Court stated that are unamendable. Fundamental rights are unamendable. So therefore, you can't amend the fundamental right. Basically, that is CAA cannot violate fundamental rights. Now, but in this judgment, Supreme Court also stated some another provisions. What are the another provisions? But Supreme Court also stated that whatever has been done earlier, it has been done. But now onwards, fundamental rights are unamendable. That is, CA cannot violate the fundamental right. So basically, Supreme Court stated doctrine of prospective overruling. That is, whatever has been done, it's okay. But now onwards, CAA cannot violate fundamental right. Now, contrasting because this judgment in the favor of the landlord. So, in contrast to this judgment, Supreme Court again passes 24th Constitutional Amendment Act and 25th Constitutional Amendment Act. So basically, Parliament against this judgment passes 24th Constitutional Amendment Act and 25th Constitutional Amendment Act. By the 25th Constitutional Amendment Act, Parliament added Article 13(1)(c), and by the 24th Constitutional Amendment Act, Parliament added Article 13(4) and Article 368 Clause 3. Article 13(4) and added 13(4) and Article 368 Clause 3. Now, what the Article 13(1)(c)? 13(1)(c) says that law made to give effect DPSP. Law giving effect to DPSP under Article 39B, 39C can violate fundamental right under Article 14, 19 and 31. Now, in the Article 13(4), the Parliament says that nothing in this article can be challenged. Nothing in this article apply on Article 368 as we discussed earlier, but now I am revising on it. But the Parliament has also added Article 368 Clause 3. So by this article, Parliament says that CAA is not CAA is not subject to judicial review. Is not subject to judicial review under Article 13. And they have also stated that CAA President must give his assent on CAA. President must give assent on CAA. And they have also changed the title of Article 360. Now, this has been done by the Parliament. So, in contrast to IC Kolkata judgment, the Parliament passed the 24th Constitutional Amendment Act and 25th Constitutional Amendment Act. And according to 25th Constitutional Amendment, they added Article 13(1)(c). According to this, they said that law giving effect to DPSP under Article 39(b), 39(c) can violate the fundamental right under Article 14, 19, and 31. In this, they have also stated that if above law mentioned a declaration that if it is give effect to DPSP, then under Article 39(b), 39(c), then cannot be challenged in Supreme Court. That is basically they have they have placed legislature more powerful than judiciary. Now, according to this judgment, again one case has been gone to the Supreme Court, and in the case of Keswananda Bharati versus State of Kerala, contrast to this judgment, the case has been gone, and the case name is Keswananda Bharati versus State of Kerala. In this judgment, Supreme Court give its various judgment. First, this says that IC Golaknath judgment was wrong. That is, CAA can violate fundamental right, but because Constitution is an organic document, therefore it can violate the fundamental right. But they've also stated in this 24th Constitutional Amendment Act is valid. Basically, they are saying that 24th Constitutional Amendment Act, under this they have stated Article 13(1), 13(4), 368 Clause 3, that is according to 13 Clause 4, nothing in this article shall apply on Article 368. But 368 Clause 3 says that CAA is not subject to judicial review under Article 13, plus President must give assent on Constitutional Amendment Act. But is valid, but judicial review part has been removed. And they also iterated that 25th Constitutional Amendment Act is partially valid. because second part of 25th Constitutional Amendment Act, that is basically this part. So this part is true, but this part is not, because it takes away power of judicial review. Now this has been happened, and again Supreme Court also give the doctrine of basic structure in this constitution. What is the doctrine of basic structure? Now we are going to discuss. Till that point we have discussed in the last class. But now onwards we will discuss what is the doctrine of basic structure and why it has saved the constitution of India to going towards the dictatorship constitution. Now let's discuss. So in the Keswananda Bharti case, Supreme Court gave the doctrine of basic structure. So basically, doctrine of basic structure says that in every society there is a periphery of the constitution and there is a core value. So you can, if there is a fundamental right, then in the fundamental right there is a periphery of the fundamental right, but the core aspect of the fundamental right cannot be violated. Basically this is the core part, so this cannot be violated, this can't be violated, and this can be violated, can be violated. So basically, doctrine of basic structure said that for every law there is a core principle. You can't violate the core principle of the fundamental right, but on the periphery you can violate for the uh, organic character of the Constitution of India. And in this case, the Supreme Court also stated constitutional morality. Basically, Supreme Court says that to value and morality of the Constitution in normal circumstances when provisions of Constitution are not as per Constitution, but if lack of clarity, therefore use philosophy of value of Constitution of India that has been driven by Constitution maker. So basically, if there is any conflicting provision, if conflicting provision, then think about the constitution makers ideology. So that has been stated in the Keswananda Bharatijan. Now let's discuss about the doctrine of basic structure. Now we know what are the various judgment we have discussed. First we have discussed कि ब्रिटेन बिहार गवर्नमेंट ने जो एक लॉ पास की थी, लॉ पास की तो उन्होंने एक लैंड सीलिंग और लैंड एक्विजिशन पर लिमिट लगा दी. इसके रिस्पॉन्स में ब्रिटिश ब्रिटिश कह रहा हूँ बिहार हाई कोर्ट ने उस लॉ को अनकॉन्स्टिट्यूशनल डिक्लेयर कर दिया और फिर इसके रिस्पॉन्स में पार्लियामेंट ने फर्स्ट कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट लॉ पास की जिसमें आर्टिकल 13(1)(b), 13(1)(a), 13(1)(b) एंड शेड्यूल 9 ऐड किया गया. 13(1)(a) के अकॉर्डिंग law giving effect to certain to attain certain objective can even violate the fundamental right under article 14, 19 and 31. And according to article 13(1)(b), they have added schedule 9 and they stated that law placed under article in the schedule 9 can even violate the fundamental right, and also they have added schedule 9 in the first constitutional amendment act, and in the response of that the case has been challenged in Sajjan Singh versus state of Rajasthan, sorry, Sankari Prasad and state of Union of India. So in this case the Supreme Court says that Parliament have two types of power: to make ordinary law and to amend the Constitution of India. If Parliament is making ordinary law, then it's subject to It's subject to classifies under law, that is, it cannot violate the fundamental right. But if Parliament uses his power as a constitutional amendment act, then it can even violate the fundamental right. So this has again been challenged in the Sajjan Singh versus State of Rajasthan, and where the Supreme Court reiterated its judgment and again says that Sup- uh, Constitutional Amendment Act can violate the fundamental right. But in this case, the judgment of the two contrasting Supreme Court judges is shaped the upcoming judgment of this on this matter. And the what is the judgment of Justice Hidayatullah and Justice Golkar? One of the judges says that fundamental rights are unamendable because you can't place the parliament equivalent to constituent assembly, which is the constitution maker. And the Justice Golkar says that there should be an implied limitation on amending the fundamental right on the parliament. In response to this, again, a case has been gone in the Supreme Court in the name IC Golaknath versus State of Punjab. In this case, 17th Constitutional Amendment Act has been challenged, and in this case, Supreme Court says that fundamental rights are unamendable. That is, Constitutional Amendment Act cannot violate the fundamental right. Plus, they have also give the doctrine of prospective overruling, that way, whether they said that whatever has been done till now, it has been happened, but now onwards, the Constitutional Amendment Act cannot violate the fundamental right. In response to this, Parliament passed 24th Constitutional Amendment Act, 25th Constitutional Amendment Act, and in the 25th Constitutional Amendment Act, they added Article 13(1)(c). According to this is stated that law giving effect to Article 39(b) and 39(c) can even violate the fundamental right under Article 14, 19, and 31. And also they have said that if any law made by the parliament contains the statement that this law give effect to 39(b) and 39(c), then it cannot be challenged in the Supreme Court. And parliament also enacted also done constitution 24th Constitutional Amendment Act, and according to this they have added 13(1), 13(4) article and 368 clause 3. 13(4), according to 13(4), they said that nothing in this article shall apply on Article 368. Basically, they are saying that whatever we are going to done, it cannot be applied on the Article 368. And 368 clause 3 says that Constitutional Amendment Act is not subject to judicial review. Plus, they have also stated that president must have to give his assent on the Constitutional Amendment Act. And they have also changed the title of Article 368. So this has been again challenged in the Kesavananda Bharati case versus State of Kerala. In this case, Supreme Court says that judgment of the IC Golaknath is invalid. That is, basically they are saying the Constitutional Amendment Act can even violate the fundamental right, because the Constitution of India is an organic document, so it can violate the fundamental right. And they have also said that 24th Constitutional Amendment Act is valid, because but judicial review part be cannot be exist. And 25th and also Supreme Court stated 25th Constitutional Amendment Act is partially valid, and they said that judicial review part cannot be taken away. And they have also told doctrine of basic structure. So they said that if any law has two types of character, that's the peripheral nature and the core aspect of that right. So Constitutional Amendment Act cannot affect the core value of the fundamental right. And they have also stated constitutional morality, where it say they say that any law, if there is a conflicting provision, then they should think with same as the Constituent Assembly while making the Constitution of India. Now, that has been discussed. Now, let's discuss more about the doctrine of basic structure. 1 minute. Now, let's discuss about the doctrine of basic structures. Now, till now, we have discussed. Now, let's discuss doctrine of basic structure. Basically, it says that law, any law, have two type of character. First is the core aspect of the character, core value of law, and another is peripheral value of law. So, Supreme Court stated that you can't violate the core value of law which has been placed under the fundamental right. So basically, core value should not be affected by the Constitutional Amendment Act. That is the basically structure. Now, who will decide the core value of the basic structure? So this for this, who will decide? So the Supreme Court stated, we will decide on the basis of case by case. Now, let us think what can be the basic structure. Basically, if it is affecting the federalism, if it is affecting the rule of law, if it is affecting the parliamentary law, if it is affecting the free and fair elections, if it is affecting the principle of welfare state, if it is affecting the secularism, if it is affecting the separation of power, if it is affecting the judicial review, if it is affecting the independence of judiciary, if it is affecting the right to inequality, if it is affecting the freedom of speech and expression, and another provisions. Basically, it will include broader concept because it will decided by the court. Then on the various judgment they have iterated that some provisions will be included as a part of basic structure of the Constitution of India. Basically, they stated federalism, judicial review, right to equality, uh, freedom of speech and expression, right to vote, free and fair election, any provision affecting parliamentary system, any provision affecting judiciary, judicial review. So these are etc. And on the some case by case basis, Supreme Court will decide that whether it is a part of basic structure or not a part of basic structure. Now, now let's discuss about एग्जाम्पल के तौर पर अगर अपन देखें एग्जाम्पल के तौर पर अपन अगर देखें तो आर्टिकल 39B सॉरी 39th Constitutional Amendment Act stated that election added Article 329A, where they said that election of president, election of speaker, election of PM, election cannot be challenged in any court. So this this has been challenged in the Supreme Court, and Supreme Court stated that it is affecting the basic structure of the Constitution. How? Because it violates the judicial review, and which is the part of judicial basic structure of India. So therefore, it will be void. Now it's little bit clear about. So in contrast to this judgment, in contrast to this judgment, Parliament again passes. In contrast to this judgment, Parliament again passes. Parliament goes and passes 42nd Constitutional Amendment Act, 1976. Now, in this Amendment Act, they have added Article 368 Clause 4 and Article 368 Clause 5 and amended Article 13C. So, according to Article 368 Clause 4 and Article 368 Clause 5, Parliament says that no constitutional amendment act can be challenged in any court on any ground. So basically they are trying to nullify the basic structure of the Constitution of India. So because they are saying that Constitutional Amendment Act cannot be challenged in any court on any ground. And they have also amended Article 13(1)(c). After amending, they are saying that no law made to give effect any DPSP called into questions or can be challenged on violating Article 14, 19, 31. So basically, on contrasting to Kesananda Bharati judgment, they have goes forward and amended the constitution by 42nd, and they have added Article 368 Clause 4 and Article 368 Clause 5, where this says that no constitutional amendment act can be challenged in any court on any ground. And they have also amended Article 13C, where this says that no law made to give effect any DPSP can be challenged on violating Article 14, 19, 31. So basically अभी तक क्या था कि अभी तक केवल 13(9)(b) और 13(9)(c) को ही इम्पोर्टेंस मिली थी फंडामेंटल राइट्स के ऊपर, लेकिन अभी तो इन्होंने कह दिया कोई भी डीपीएसपी, तो all DPSP are placed more importance than fundamental right. So this Constitutional Amendment Act is again going to be challenged in the case of Minerma Mills versus State of Constitution of India. So this This challenged in Minerva Wills versus Union of India. So in this case, Supreme Court upheld the validity of Article 368(4) and 368 Clause 5. So basically what the Supreme Court said? Supreme Court said Article 368(4) and 368(5) are violating basic structure of the Constitution of India. How? Because judicial review is the part of basic structure, and if you are saying that it cannot be challenged, basically you are saying that it cannot be judicially reviewed. That the Supreme Court said that Article 368 Clause 4 and 368 Clause 5 are void, are unconstitutional because it's take away the judicial review which is a part of Constitution of India. Now, also Supreme Court stated that Parliament cannot use limited amendment power amendment power to give itself अनलिमिटेड पावर। अभी तक देख रहे हैं हम भैया कि खेल खेल रहे हैं ये लोग। पार्लियामेंट आती है, लॉ पास करती है, सुप्रीम कोर्ट आता है, जजमेंट सुनाता है, फिर पार्लियामेंट आती है, फिर लॉ पास करती है, फिर जजमेंट आता है, फिर पार्लियामेंट आती है, लॉ पास करती है, फिर जजमेंट आ जाता है। तो फिर पार्लियामेंट ने कहा कि सुप्रीम कोर्ट ने कहा कि भाई ऐसा है पार्लियामेंट, अब आप अपने आप को ज्यादा पावरफुल बनाने के लिए बार बार कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट मत पास करिए। सो बेसिकली दे हैव लिमिटेड amendment power now, and Supreme Court also stated in the Minerva Wills case, Supreme Court also stated that Supreme Court also removed the part of 13(1)(c). So Supreme Court removed 13(1)(c), that is where all DPSP cannot violate fundamental right under Article 14, 19, 31. Basically, now the same provision has been come that it can violate only Article 39B and 39C. Now, this judgment has been given by the Supreme Court of India. Now, let's move forward. What about the Schedule 9? So, this judgment has been given. Now, we have discussed that no judgment has been given on the Schedule 9 because in the case of IC Golaknath, the Parliament has made Schedule 9 and said that any law placed in Schedule 9 cannot be challenged in the Supreme Court. But no discussion has been happened on Schedule 9 till now. So in case of in the case of IR Kolio versus State of Tamil Nadu. In this case, Supreme Court stated that law placed under Schedule 9, Supreme Court stated law placed under Schedule 9 is also subject to judicial review. So they cannot enjoy the complete immunity because judicial review is part of basic structure of the Constitution of India. And also Supreme Court laid down in this case twofold test. What is the twofold test? Let's discuss. So twofold test is that if you are placing any law under Schedule 9, then it's subject to judicial review. So basically, Supreme Court said any constitutional amendment act is subject to judicial review because judicial review is part of basic structure. And they've also stated any law, any constitutional amendment act giving effect to Schedule 9 is also subject to judicial review. Now, this has been happened in the IR Kohli versus State of Tamil Nadu. Now, this has been now onwards that this process has been followed. So we have discussed all the provisions till now. So now let's discuss one more times so that it can make easy. So now Bihar government introduced Land Reform Act and Bihar High Court declare is unconstitutional. So in the response of that, Parliament enacted the first Constitutional Amendment Act and added Article 13(1)(a), 13(1)(b). According to 13(1)(a), Parliament says that law giving effect to certain objective can even violate the fundamental right under Article 14, 19, and 31. And 13(1)(b) says that law placed under Schedule 9 cannot be challenged in the Supreme Court. And in this first Constitutional Amendment Act, they have also added Schedule 9. In response to that, landlord challenged the judgment, this Constitutional Amendment Act, that in this case of Sankari Prasad versus Union of India, where Supreme Court stated that Parliament has two type of power. One is to make ordinary law, second is to make constitutional law. When Parliament is making the ordinary law, then it's subject to law under Article 13, which cannot violate the fundamental right. But if Parliament is making Constitutional Amendment Act, then it can even violate the fundamental right. So this then the again in the Sajjan Singh State of Rajasthan, this has been challenged, and Supreme Court again reiterated the same judgment of the Sankari Prasad cases. But in this judgment, the contrasting judgment of the two judges, where they say that fundamental rights are unamendable. Basically, you can't place the constituent, you can't place the parliament equivalent to the Constituent Assembly who has drafted the Constitution of India. And another judge says that fundamental right there should be implied limitations on the parliament to amend the fundamental right. In contrast to the judgment, this has been challenged again in the IC Gulaknath case, State of Punjab. In this case, 17th Constitutional Amendment Act has been challenged in court, where Supreme Court stated that fundamental rights are unamendable and CAA cannot violate fundamental rights. Plus, they have also stated doctrine of prospective overruling. They said that whatever has been done, it has been done, but now onwards, CAA cannot violate the fundamental right. So this judgment has been given in the favor of landlord. But in response to that, Parliament again passed the 24th Constitutional Amendment Act and 25th Constitutional Amendment Act. According to 25th Constitutional Amendment Act, they have added Article 13(1)(c), where this says that law giving to DPSP 39B and 39C can violate the fundamental right under Article 14, 1931. And they've also stated that if any law, if above law is contained declaration that it contained declaration that this law is giving effect to schedule to giving effect to DPSP under Article 39B and 39C, then it cannot be challenged in the Supreme Court. And according to 24th Constitutional Amendment Act, Parliament says and added Article 13(4) and 368 Clause 3, where they said that nothing in this law shall apply on the Article 368. And Constitutional Amendment Act is not subject to judicial review under Article 13. And they have also stated President must have to give his assent on Constitutional Amendment Act. This has been again challenged in the Kesananda Bharti case versus State of Kerala, where the Supreme Court stated that IC Golaknath judgment has been wrong. Basically, they are saying that fundamental rights are amendable, they can be amended because Constitution of India is an organic document, so it can be amended. But Supreme Court also stated 24th Constitutional Amendment Act is valid, but in this provision, judicial review cannot be taken away. Now, 25th Constitutional Amendment Act is partially correct, and the second part of the 25th Constitutional Amendment Act is not exist. That is basically it will be void and it will be unconstitutional. And Supreme Court also laid down doctrine of basic structure in this case. So, like, what is the doctrine of basic structure? Doctrine of basic structure basically says that if any fundamental right have two types of value, first is the core value and another is the peripheral value. So Constitutional Amendment Act cannot violate the core value of the law. So basically, they have said that fundamental right cannot, sorry, Constitutional Amendment Act cannot violate the core value of the law. So we have discussed what is the core value. Core value is basically federalism, parliamentary law, judicial review, right to vote, right to freedom of speech and expression. And on the case by case basis, Supreme Court will decide what is the core value of the fundamental right of any particular case. Now, again, this has been challenged in the 42nd Constitutional Amendment Act, and so sorry, against this judgment, Parliament passed 42nd Constitutional Amendment and added Article 368(4), 368(5), where this says that no Constitutional Amendment Act can be challenged in any court on any ground. So basically, they have placed all the DPSP, all the Constitutional Amendment Act more than judicially review. And they have also stated 13(1)(c), where they said no law made to give any DPSPs can be challenged on violating Article 14, 19, and 31. This has been again challenged in the Minerva Mills versus Union of India, where Supreme Court stated that 368(4), 368(5) are unconstitutional, so they cannot, because judicial review is the part of basic structure of the Constitution of India, and they have also stated Parliament cannot use limited amendment power to give itself more power. And Supreme Court also removed Article 13(c), 13(1)(c), that where all DPSP get more right, cannot get more right under Article 14, 1931. Now, this has been till now. But in the schedule, in the IC Colio versus State of Tamil Nadu, Supreme Court stated law placed under Schedule 9 is also subject to judicial review because judicial review is a part of the basic structure of India, and Supreme Court also laid down two-fold test that any law, any constitutional amendment act is subject to judicial review because judicial review is the part of basic structure of India, and by a constitutional amendment act, If any law giving effect to Schedule 9, then it can also be subject to judicial review. Now, this has been now till now. Now, move forward. Let's discuss Article 14 to 18. Right to equality. Now we have discussed. Is that okay? Now let's discuss Article right to equality. Article 14 to 18. Let's read once. 14, 15, 16, 17, 18. As we have already told you, you have to purchase this book, so that I am studying on this book, so this will be helpful for you. So now, Article 14 to 18, basically right to equality. So the Article 14 says that the state shall not deny to any person equality before law or equal protection of law within the territory of India. So basically, Article 14 says that state can't deny to any person before equality before law and equal protection of law. EBL basically equality before law and equal protection of law within the territory of India. Basically, it limits the power of states. So now let's discuss what is the mean of equality before law and what is the mean of equal protection of law. So basically, let's discuss first equality before law and equal protection of law. So let us first discuss about equality. What is do you mean by equality before law? So basically, this concept has been taken from the UK. This concept says that irrespective of the social status, of the political status, of the economical status, every person, irrespective of the social status, economic status, political status, every person is equal before law. So basically, it says that no special privilege to any person in favor of in favor of any person. Even it can be poor, it can be socially marginalized, it can be economically marginalized, it can be politically backward. Irrespective of these all aspects, all the people, all the persons are equal before law. Basically, it is strict with respect to law. Now, what are the exceptions? Now, what is the equal protection of law? Let's discuss about the equal protection of law, EPL. What the EPL says? EPL is basically taken from the USA, and it says that the state shall not discriminate against any person or a class of person. State can't discriminate any person or a class of person. So basically, India has adopted both systems, equality before law and equal protection of law. Equality before law says that all persons are equal before law, whether irrespective of their richness, irrespective of their poorness, irrespective of their marginalized, irrespective of their backwardness, no matters, all are equal. But equal protection of law says that state cannot discriminate any person or a less or a class of person. So basically, they are saying that if any person is a poor person, so you can't discriminate on the basis of their poorness. If any person is a rich person, then it can very easy for him to hire an advocate, to hire authority, so that decision can be favor in that person. But in case of poor person, they can't afford the advocate, they can't afford to purchase any authority, they can't afford to give the money. So basically, state will try to not discriminate on the basis of poorness, on the basis of marginalized, on the basis of other provisions, which can even lead to the violation of their social status, political status, and the economical status. Now, so basically, this is the equal protection of law. Now, so this is the basically. Now, let's discuss. There are some immunity has been provided under Article 14 to some constitutional post. What are these posts? Basically, Article 14 says that all state cannot deny to person before equality before law and equal protection of law. So equality before law, as we have discussed, that no special privilege in favor of any person from you, and protection of law states that state cannot discriminate any person on the basis of their status, their backwardness, etc. But there are some immunity has been provided in the Constitution of India to some constitutional posts. So immunity provided to some constitutional post. What are the constitutional posts? First, what are these posts? First, according to Article 361, President and Governor cannot be held legally liable, cannot be legally liable on doing their official work, because basically this is saying that if any president or governor has done the work which is against some provisions, that then the president and governor cannot be held legally liable, because the governor and the president are not acting on its discretionary power, because they are acting on the advice of council of minister. uh, President is acting on the advice of Union Council of Minister, state is acting on the advice of State Council of Minister. So this decision is not taken by the president. This decision has been taken by the Council of Minister. So why the president and governor will be held legally liable? So that's why president and governor have got immunity under equality before law while doing their official work because they are acting on the advice of Council of Minister. And Article plus no criminal proceeding, no criminal procedure initiated against president and governor. So basically, no criminal proceedings can be initiated against the president and the governor during their office. Now again, other some also that no arrest and imprisonment of president or governor, no imprisonment to governor and president during holding office. And also another postage which got immunity, no civil proceedings, no civil proceeding can be initiated against president and governor. If it has been initiated, then at least 6 month approval should be needed before initiating the civil proceedings. And one also post which has got the complete immunity over this. So now, according to Article 105 and 194, MP, MLA is not held to legally liable for action done in parliament or legislature. And also, one also post which has got the complete immunity, basically diplomat of foreign state in India got complete immunity on Indian rule. Now I think it will be clear. These are some constitutional posts which got complete immunity before equality before law. According to Article 361, President and Governor cannot be held legally liable while acting their official work. No criminal proceedings can be initiated against the Governor and the President during their office. No imprisonment can happen to Governor and the President during their office. No civil proceedings can be initiated. If it is initiated, then at least 6 month approval should be needed from the Governor. And according to Article 105 and 194, MP, MLA, MLC cannot be held legally liable for action done in the parliament or the legislature. And also, immunity has been provided to diplomat of the foreign state which are acting in Indian territory, basically the ambassador of the another country, whether the representative of the international organization which are acting in the Indian territory cannot will be completely immune over the Indian rule. So these are some basically constitutional posts which have got complete immunity over constitution over equality before law. Now let's move forward. Now let's discuss about the equal protection of law. What do we mean by equal protection of law? So we have discussed in the broad concept equality before law. Basically, all persons are equal before law, and there are some constitutional posts which has got complete immunity over the uh, equality before law. We have discussed all the provisions. We have discussed all these posts. Now, let's discuss equal protection of law. So, as we have told you earlier, that this concept has been taken from the USA. So now we are discussing equal protection of law. So again, we are stating that it has been taken from the USA. Basically, state will not discriminate to any person. No, basically, in India, this process has not been adopted. There is a Indian version of equal protection of law. So what is the Indian version? Indian version of equal protection of law states that state can discriminate. State can positively discriminate. Basically, what we mean by positively discriminate, that state can make the policies, make the program in the favor of poor class. So basically, they are discriminating the richer class. So state can discriminate positively to various sections to upliftment of their backwardness, to upliftment their social status, to upliftment their educational status, to upliftment their political status. Now, basically, Indian equality before law, equal protection of law says that equals should be treated as equally, unequal should be treated as unequally. Is that clear to you? Now let's move forward. So basically, according to this Indian एग्जाम्पल के तौर पर अगर बात करें तो वेरियस पॉलिसीज प्रोग्राम which positively discriminate to poor sections or other sections for upliftment. Example, reservation criteria in India, in politics, in educational institutions, in government jobs, etc. Now, now let's move. We have discussed Article 14. What do we mean by equal protection of law? What do we mean by equality before law? We have discussed all of this. Now let's move forward to Article 15 of the Constitution of India. What the Article 15 says that Article 15, let's read once, then we will discuss. Article 15 says that prohibition of discrimination on the ground of religion, race, caste, sex, or place of birth. So basically, Article 15 have originally three clauses. Article 15.1, 15.2, 15.3. According to Article 15.1, state shall not discriminate against any citizen on ground of only of caste, religion, sex, place of birth, race, or any of them. So basically, Article 15.1 says that state shall not discriminate against any citizen on the ground of religion, race, caste, sex, place of birth, or any of them. So basically, these are saying ओनली ऑफ का मतलब क्या है? ओनली ऑफ का मतलब यह है कि भाई यही ग्राउंड है, इसके अलावा कुछ और नहीं है। कास्ट के बेसिस पे, रिलीजन के बेसिस पे, सेक्स के बेसिस पे, प्लेस ऑफ बर्थ के बेसिस पे और रेस के बेसिस पे, या इन चारों में से कोई भी कम्बिनेशन हो उसके बेसिस पे स्टेट डिस्क्रिमिनेट नहीं कर सकता। लेकिन state can discriminate on the grounds which are not mentioned. Basically, state can discriminate on the educational criteria. State can discriminate on the professional criteria. State can discriminate on the ability criteria. So state can do so, but state cannot discriminate on the basis of these ground only and any of the combination of these ground. So this is the provisions which has been mentioned in Article 15.1. Now let's read Article 15.2 once. So no citizen shall on ground of only of religion, race, caste, sex, place of birth, or any of them be subject to any disability, liability, restriction, or condition with regard to access to shops, public restaurants, hotels, and place of public entertainment, the use of wells, tanks, bathing guards, roads, and places of public resort maintained wholly or partially out of state fund or dedicated to the use of general public. So basically, Article 15 Clause 2 says that no discrimination with respect to public good, public places to citizen. सो स्टेट इंश्योर करेगा कि भाई कोई भी ऐसा डिस्क्रिमिनेशन पब्लिक के साथ ना हो जो स्टेट फंडेड हैं या पब्लिक प्लेसेस हैं या पब्लिक मॉल्स हैं, ऐसी कोई भी जगह पर सिटीजन्स के साथ डिस्क्रिमिनेशन नहीं होना चाहिए। क्लियर है? सो दिस, अच्छा इसमें याद रखने वाली बात क्या है कि आर्टिकल 15 क्लॉज 1 में केवल और केवल स्टेट के बारे में कहा गया है। स्टेट डिस्क्रिमिनेट नहीं कर सकता, लेकिन पर्सन डिस्क्रिमिनेट कर सकता है कि भाई चलो स्टेट नहीं करेगा लेकिन मैं चाहूंगा तो कर दूंगा डिस्क्रिमिनेट। मैं अगर चाहूँ on the basis of caste, on the basis of religion, on the basis of sex, on the basis of race, on the basis of place of birth, I can discriminate, but state cannot discriminate. But Article 15 Clause 2 says that even state and even a person, मैं भी और स्टेट भी, दोनों डिस्क्रिमिनेट नहीं कर सकते एनी पर्सन, किसी भी पर्सन को डिस्क्रिमिनेट नहीं कर सकते ऑन द बेसिस ऑफ कास्ट, सेक्स, पब्लिक गुड एंड प्लेस ऑफ बर्थ और एनी ऑफ देम. So this has been mentioned in the, so basically here state and citizen both cannot discriminate. Now, Article 15 Clause 3. What the Article 15 Clause 3 says that? Let's read once. Article 15 Clause 3 says that nothing in this article shall prevent the state for making any provisions for women and India. So basically, Article 15 Clause 3 says that state can positively discriminate to make in favor of women, children. एग्जाम्पल की तरफ पर आएगा रिजर्वेशन टू वुमेन. So these are the provisions which has been originally mentioned in the Article 15 of the Constitution of India. Now, in Article 15 Clause 4, nothing in this article or in Clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of the socially, educationally backward class of citizens for the scheduled caste and scheduled tribes. So basically, state can also make state can also positively discriminate in favor of backward classes, STs and SCs. So this is the Article 15 Clause 4 says that. Article 15 Clause 5 says that nothing in this article or in subclause G of Clause 1 nothing in this article or in subclause G of clause 1 of Article 19 shall prevent the state for making any provision by law for the advancement of the socially educationally backward class of the citizens or for the scheduled caste or the scheduled tribe is so far as such special provisions relate to their admission to educational institution including private educational institution whether aided or unaided by the state other than the minority educational institution referred to in clause 1 of article 30. So Article 5 says this. Now let's move on the Article 16 first. Then we will discuss the another provision of the Article 15 clause 4, 15 clause 5, 15 clause 6. So first move Article 16, then we will discuss more about the Article 15. So now let's first read Article 16. What the Article 16 says that equality of opportunity in matter of public employment. There shall be a equality of opportunity for all citizens in matter relating to employment or appointment of any office under the state. So basically, Article 16 says that equality in matter of public employment. So basically, Article 16, as we have discussed, that 16 clause 1 says that equality of opportunity with respect to jobs. Article 16 clause 1 says that there shall be equality of opportunity मतलब ST और SCs के लिए आप अपॉर्चुनिटी देंगे कि इक्वालिटी आ सके गवर्नमेंट जॉब में. एग्जाम्पल अगर अपन बात करें तो एग्जाम्पल पे अपन बोल सकते हैं रिजर्वेशन प्रोविजन, रिजर्वेशन इन जॉब्स. नाउ लेट्स मूव आर्टिकल 16 क्लॉज 2. 16 clause 2 says that no citizen shall, on ground only of religion, caste, sex, descent, place of birth, residence, or any of them, be ineligible for and discriminated against in respect of any employment or office under the state. Now we will discuss. Let's wait.